My name is Mr. Max Chaudhary of Chaudhary Law Office. We're an immigration law firm in Midtown Toronto, and I have these webinars periodically for the purpose of bridging the gap between people who are sort of searching on the internet about a question, but they may get misled, arguably, by some of the responses that they may see online, such as through online fora and things of that nature. And so this is an opportunity to give at least some general direction to the question or issue you have. And as I've indicated, because a lot of this will be on social media in excerpts, then you want to, as particularly if you're dealing with more enforcement-minded issues like deportation or investigation by the border authorities, you definitely want to keep your identity anonymous for that purpose. But as is implied, we do that kind of work as well, not just bringing people into Canada, but trying to keep people who are inside of Canada, legally inside of Canada, through various methods. So traditionally, the ideal format for this would be to pose questions and ideally pose them in the chat. And that way I can try to digest those questions and go by memory about the relevant statutes, such as the Immigration and Refugee Protection Act and things of that nature. Sometimes the question you pose may lead to further clarification being needed, in which case you can pose further details about that in the chat. I'm just going to open the chat. I believe I had received something like 30 questions. I have them somewhere, and presumably some of those people are here now and may want to repose those questions, because that way, since they are here, then they can try to take advantage of having their question answered within the time we have today. In the absence of any questions now, I just want to remind people about something I tell people all the time, which is that when you're searching for a particular immigration question online, the sort of hierarchy of what to look for in terms of the source is obviously the government website. So that would be, in the Canadian context for immigration, cic.gc.ca. And in some cases where there is a interaction you have, which is sort of a hybrid interaction, which may relate to enforcement and coming to Canada, such as trying to enter Canada, then sometimes the Canada Border Service Agency website, which is .cbsa.gc.ca. In contrast, you will find issues or difficulties if you are searching online forums or fora, as sometimes these are very anecdote specific and they do not necessarily indicate the right thing to do, but rather only that somebody tried a certain course of action and it worked for them. So without looking at the individual circumstances of yourself versus that person whose situation might be the same, then it's impossible to be confident about whatever that person did and whether that would work for you is actually the right thing to actually do. Sorry. So with that in mind, I see the questions here. There's at least one here. So this says, in terms of a visitor visa status, I have a visitor visa of Canada. If I'm inside Canada, can I convert it to a study permit? And secondly, if I get the study permit, what would be the status of my kids and spouses? So technically speaking, you could be physically present inside of Canada as a visitor and file for a study permit application. Keep in mind the study permit application would be decided most often by a Canadian visa office outside of Canada. Traditionally, well, I shouldn't say that. I mean, maybe 20 years ago, interviews were not uncommon for study permit applications, but now because the volume of for study permits, the volume of study permit applications is so high. I've never heard of anybody being interviewed in the past 20 years. So that's one aspect which is in favor of filing for a study permit while you're a visitor inside of Canada. Keep in mind, though, that when you file a study permit inside of Canada, or while you're physically inside of Canada, this could have an effect on the Canadian visa officer's perception of what your ties to your home country are, because as many people know or should know, a temporary resident visa is temporary, obviously, but also a study permit is temporary. So in an extreme example, if you've been a visitor to Canada, let's say you've got a 6-month extension 3 times, so you've been in Canada for 18 months, and at that juncture, you're applying for a study permit, it could be a legitimate concern for the officer that you may not have sufficient ties to your home country. You could try to mitigate that by having a specific plan of study that shows the utility of that study for re-entering or reintegrating into the labor market of your home country. But that's just one example of how it's theoretically possible, but there could be some issues. The related question is, if I do get the study permit, what would be the status of my children and spouses? I think it's spouse, I hope, right? Because we don't allow bigamy in Canada. So in that situation, if you're, let's call you the head of the family, man, woman, whoever, for the purpose of immigration, you'd be the head of the family. Then at the same time, your spouse would have to apply for, depending on your program, they could apply for a work permit. I believe you have to be going to a professional program or master's of 16 months, or your spouse could apply for a visitor visa, and the children could apply for visitor visa. If your entry as a student is for more than 1 year, then your children, if they are underage, if they are under high school age, they should be able to study in Canada while you're studying, assuming the duration of your study permit is a year. That's the norm for that. So, I mean, if there's a follow-up, you can please pose that in the chat as well. There's another question related to a procedural fairness letter, which is a common way for IRCC and the Canada Border Service Agency to probe some aspect of your application, usually in writing, hence the word letter in procedural fairness letter. So this individual says, I've received, or if I've received a PFL or a permanent resident application due to foreign experience paid in cash, how to submit the proof? Okay, so this is extremely important because if you have a permanent resident application, particularly under express entry, it's so competitive. So you want to avail yourself of the best possible evidence to respond to that. Sometimes they only give 7 days for this. If that's the case here, then you should ask for an extension. If you do not have the best possible evidence, there's a rule in Canadian law, I think it comes from immigration law, that you should try to have the best evidence. And in the absence of the best evidence, you must have an explanation for why you don't have what might be construed as the typical best evidence in a given situation. If I take the officer's point of view about this, there's a concern that you're applying presumably under express entry, which requires proof of paid work experience. So a key element for your foreign work experience to be counted, and hence your points to reach a certain threshold, is that it's work experience with the related evidence. So that's a work reference letter and evidence of remuneration. If it was cash, then we look at what are the ordinary circumstances of the average person. Perhaps it was paid with cash and you deposited the cash. If you did not deposit the cash, explain why you did not. In some situations, I've read in certain jurisdictions, people keep cash not in the bank, or they keep a significant amount of cash somewhere other than the bank. Not to say they're doing something illegal. They just, for some particular reason, culturally based, they keep a chunk of cash at their residence. That might be a pattern, a consistent pattern in some places. Maybe that's your situation. I don't know. But when you start to get away from the officer's normative expectation, namely that you get cash and you put it in the bank to get the 1.5% interest or whatever, then you have to become more specific with your explanation. And then with the specificity, you need a credible source for that specificity. In a hypothetical situation, if there was economic collapse or catastrophe in your country, then there may be a genuine reason you may not want to put the money in the bank in case it gets seized by the government, for example. I use that as a sort of illustrative edge case. But that is something which, if that were the situation, you would be able to point to publicly available news events showing that there was a run on the bank at the relevant time, preferably recently, or maybe at the time you were working for this outside of Canada employer. There was an economic set of uncertainties, so people would just not put money in the bank, that kind of thing. Related evidence would be whoever paid you. They could try to corroborate that as well. A well-drafted affidavit from the employer who paid you could be possibly a substitute for this kind of concern that is being expressed by the officer. So these are examples of credible third-party proof. It's not the best when you get an affidavit because you're getting the affidavit after the incident occurred, so it's not organically generated evidence, such as what I mentioned earlier, which is maybe a bank deposit shortly after you got paid before this procedural fairness letter was issued. So that has a hallmark of more trustworthiness because it's a document that was not generated in response to a PFL, but was just generated organically. So I hope that gives some guidance for addressing a PFL. Because the stakes are high, you may want to get actual legal advice about that, and you can do that through our office. That's the periodic plug I may engage in during the course of this webinar. So with that in mind, next question is, I'm currently based in the United States, working under OPT status, and I'm interested in applying for Canadian permanent residency and would like to determine which option is the best option. And this person adds, I do have a PhD and 2 years of work experience. Do you think I'm qualified to apply through any method? And how would I start working with you? So there's always this necessity to go from general to specific. And so that kind of analysis means that we have the law, the general law, IRPA, Immigration Refugee Protection Act, the regulations, Immigration Refugee Protection Regulations. That's general. And then from the specific, we look for the express entry provisions, which are embedded, I believe, in Regulation 10. That's one aspect of it. And also the ministerial instructions, which are oftentimes have the force of law, but are not embedded directly in law, but are in policies, which is frustrating because immigration law has a lot more policies than other types of law. And then this analysis from general to specific also applies for the candidate. So when the candidate says, as is here, the person has a PhD and 2 years work experience, then we put it through the lens of what is relevant based on the legislation. So for example, if we see 2 years of work experience, we'd say, oh, okay, have those 2 years been completed within the past 9 years? Because outside of Canada, work experience in the past 9 years is counted. towards express entry. So that's something we would ask. The other aspect is age, because age might make it completely not even worthwhile to consider express entry, except in rare circumstances. For example, if you're age over 35, these days, the only express entry draws I'm seeing for people over 35 are those who are fluent in both the English and French languages and have work experience. And then these are basically the targeted draws, in this case French, because for whatever reason, the federal government has determined that they want to increase the amount of French speakers in the French communities outside of the province of Quebec. So that's another factor we'd look at. The person mentions they have a PhD. Do they have the ability and desire to do something analogous to a postdoctoral, like something related to a master's? If that's the case, then I believe in Ontario, and I believe more recently, maybe Manitoba or Saskatchewan, they have a master's stream and PhD stream as well. And at least in the Ontario context, because I'm more familiar with that one, the criteria is relatively straightforward. Namely, you complete a master's level or PhD level program, and you signal an intention to apply in Canada and reside in Canada within, I believe, 2 years of completing that post-secondary credential. And as long as you've completed that credential and you're in Canada or in Ontario specifically, then that's really all they need to issue you the permanent residency. That is subject to the caps, because the provincial nominee programs, of which this is one, is subject to the amount of spots given by the federal government. I believe Ontario had 9,000 this year, but that has to be split between the various streams. Ontario has like human capital priority stream and employer job offer stream, and things of that nature. So that's something else we'd want to explore to try to determine the most optimum situation. And a sort of a more minute point is that if somebody does have 2 years of work experience outside of Canada, what's also relevant for express entry is not merely that it's completed less than 9 or 9.5 years ago, but also did at least one venue of work experience outside of Canada take place at one place of employment for more than 1 year, which is an odd requirement, but that has to be the case for your foreign work experience to be counted under the express entry program. So we always say, again, the shameless plug here is to consult with us. And then we can triangulate your credentials in relation to the more specific relevant policies and ministerial instructions and legislation of express entry. So next question is it possible to apply for a work permit from inside of Canada while on a visit visa? I get this question a lot. There is a policy change that makes it very difficult now. So the norm as of now, if you are considering applying for a work permit from inside of Canada, a similar rule to what I mentioned earlier about study permit applications applies, which is that you could be on a genuine, valid, subsisting visitor status in Canada, but if you do apply, you would have to apply for a work permit outside at a Canadian visa office outside of Canada. So a lot of the concerns about the officer, about you being a genuine temporary resident, namely, are you going to return to your country of citizenship or country of ordinary residence after your work permit expires? That question might become more complicated if you have a history of being in Canada on a visitor status for a longer time. So technically, yes, but you do have that issue. And you should be aware that oftentimes these days, because the temporary status is getting so restricted, you generally have to have a job offer for this, unless you're coming under some exemption, such as, let's say you're a person who is married to a Canadian and you're being sponsored as a spouse. Then in that case, you can apply for a spousal open work permit without a job offer. You just have to be in Canada and be uh, basically complying with the applications you've made, such as living with your spouse in the case of applying for a spousal application. And keep in mind also that some of these job offers require LMIAs, labor market impact assessments. Um, so those are different from what we call international mobility, which is intra-company transferee, being transferred from a U.S. branch to the Canadian branch of the same employer. But in any event, as of now, 2025, and probably in the past 2 years or so, the norm is that you have to apply at a Canadian visa office outside of Canada. During COVID, just because there was simply no ability to travel, there was a time, perhaps for a year or two, maybe 2.5 years, you could apply for a work permit inside of Canada. Arguably, that led to some of the issues now, where we have, especially for 2024 and 2023, a tremendously huge amount of temporary residents in Canada. But now with that policy gone, you have to apply outside of Canada, and you probably need a job offer unless you're coming under the International Mobility Program, or you're from a country with a treaty agreement, where there's working holiday programs for people of a certain age, typically with the more economically stable countries like Australia and Western Europe. And those countries have those kinds of agreements. So in terms of other questions, mentions here, somebody's indicated, I've done my bachelor's from the United States, and I have a visit visa for Canada. Can I get a study permit while staying in the United States? And if I can, once I complete my degree, I think that's what they meant to say, will I be eligible for PR, and how long does that take after getting my degree? So, assuming the person is not a U.S. citizen, U.S. citizens can actually apply for a study permit at the border. I think they're the only types of citizens who can do that. Everybody else has to apply the regular way, which is at a Canadian visa office abroad, typically. So in a circumstance where the person has a visit visa, in terms of the relevance of that to the study permit, arguably it's a stronger indicator that you would be successfully granted a study permit, because a lot of the criteria for the issuance of a visitor visa, namely ties to home country and genuineness of temporary intention, a lot of that overlaps with the criteria for a study permit. There's a bit of a structural concern, namely that if you've done a bachelor's in the United States, that means you've been in the United States for at least 3 or 4 years. Then there's a potential concern that what are you going to do with this Canadian study? Because you've already demonstrated a pattern of being in North America. And so that could theoretically cast doubt on whether you have a genuine purpose or intention to return to your country of citizenship. Again, you can mitigate this with a cogent plan of study, which shows the relevance of the studies or proposed studies in Canada in relation to, for example, competing in the labor market of your home country. That would be sort of the foundation for proving the genuine intent to be a temporary resident. This all sounds a bit crazy if you're familiar with the well-worn pathway that was well-worn from 2015 until 2022, namely that it was something of an unspoken assumption that if you studied in a program of 2 years, and if that did lead to a post-graduation work permit, and if you did work for 1 or 2 years in Canada, it was almost a safe bet that you would get PR. But now there's the proliferation of targeted draws, and in the absence of you coming under a targeted draw, namely related to healthcare or French language skills or certain niche occupations or teacher, then simply studying in Canada in a course of study is no longer as safe a pathway for permanent residency in Canada. So that shifts the burden on the potential study permit applicant to really focus on the applicability of their course of study to presumably integrating in the labor market in their home country, unless they're independently wealthy and maybe they want to study something in Canada that is not available at post-secondary institutions in their home country, or maybe not available in their adjacent home countries where they may possibly study for less of an expensive price due to a cost of currency, that kind of thing. So there's a lot more that has to go into a study permit application now, such as those issues, right? So that I hope that gives some pathway or a bit more specificity for this. So there's other questions too. Okay, no, I see perhaps a related question, which is, I think it relates to the question I've just been asking, or answering rather, where the person says they're a psychologist. Okay, I like that. We really like that a lot now, right? Because targeted draws mean, especially those related to healthcare, that is something of a lot of relevance. And they have work experience. Presumably, I'm going to just presume they have the 7 years of work experience in the past 9 years. And they have a master's degree. 34 years of age is not bad. But the related question to all this is which PNP programs are preferred. So provincial nominee programs, I touched upon them briefly in the context of how they are allocated caps by the federal immigration department. Ontario gets 9,000, as I said, and the other provinces, I forget, maybe British Columbia gets 3 or 6 or something, 6,000. So when we look at the utility of provincial nominee programs for a potential candidate seeking permanent residency to Canada, the fundamental aspect, probably 85% of the time or 90% of the time, is that there is a job offer. So in the PNP, or provincial nominee program scheme of things, the job offer sometimes is scrutinized by the province's immigration authorities, because each province has a department of immigration as well. And in some cases, such as Ontario, where there is a program related to in-demand jobs in rural areas, then basically how that unfolds is that the municipality registers with the province through credible business people in that community that we need X type of persons for this set of tasks. So in other words, we need certain types of people. And then if the candidate does go to, I believe one place is Thunder Bay, Ontario, and they do acquire that job offer with the registered employer, then that could be the pathway for PR. From my understanding, the rationale is that the province of Ontario does not want to keep having people just rush to Toronto because the infrastructure is not capable of handling it. And also they want to revitalize the smaller cities within the province of Ontario just because it's more environmentally responsible, and they want to deal with the demographics where there's older and older people residing in these smaller cities. So if we loop all of that back into the question about P&P for a psychologist, I'm thinking of, for example, some other provinces like British Columbia, where, and Nova Scotia as well, where they have pathways for medical professionals. Now, for Nova Scotia, I think it's restricted to MDs, not psychologists, but there is a pathway there. But again, that's job offer based. So the other concern is that if, and I don't know this off the top of my head, whether the licensure for practicing as a psychologist, whether there's some transferability or portability between US credentials and Canadian ones. If there is, then let's take that as the premise and that you put in an express entry profile. Based on the history of targeted draws for healthcare, because there's periodically those, the fact that you have age of 34 may not be as bad, because oftentimes the healthcare draws are being targeted are subject to a much lower point threshold. Instead of the norm of like 530 or 540, the points go down significantly to 400 something. And that could attenuate the negative effects of having more age exceeding age 30, because the points start to go down at age 30. So that's when you do an express entry profile, you can indicate you intend to reside in any province, and if a province does have a need for a psychologist, then they could automatically select you for that particular province. That's not the way to be comprehensive, though, because if you're really serious, you want to look at each individual province's regime for health professionals and see if they do have a roster of approved employers. In some cases, I've mentioned Nova Scotia, oftentimes institutional employers or quasi-government employers like hospitals in Canada, they already have an arrangement with the province to streamline the approval of the job offer process to kind of mitigate the sort of more lengthy certification of the job offer. To, in other words, get rid of the sort of slow LMIA, labor market impact assessment process. So that would be one way. So you're covering both bases if you have an express entry profile, but also if you explore what are known as occupations under pressure in a given province and see if psychologist is on that list. There is a stream, I believe, I always confuse it if it's Saskatchewan or Manitoba. I think it's Manitoba, where they have their own stream and their own point system for people with foreign work experience. And they have their own occupation list. So that could be something which you would have to pursue outside of, in addition to, the ordinary federal express entry system. And for that, the key element there is, number one, being lucky enough to see your occupation on the list, but also to prove that you want to live in, for example, Winnipeg, Manitoba, which has been described by many people as a inhospitable winter hellscape. So depends on what your priority is, and if there's a need for your job in Canada. So I hope I've addressed that. So if we look further, we still have time. So I'll just try to distill the fact scenario for this individual, where it says, I came to the United States about 3 years ago on a student visa, but I could not complete my studies. And after that, I applied for asylum, and I'm still in the United States under that status. I also have a visitor visa for Canada, and I'm thinking about moving to Canada because of the administration in the United States, which we understand. Right now, the person is working as a medical biller and owns a small business in the United States. So it seems like they're multitasking. And with that set of credentials and experience, it is being asked, What are the options to travel to Canada, to change status to some kind of business permit or work-based status? And then hopefully I can keep all this in my head. Also, it says, related to the same question, because of my current asylum status in the United States, I wanted to check, could that affect my entry into Canada? And if I don't qualify for any business or work options, would I still be eligible to apply for asylum in Canada? So this touches upon two broad pathways. One is the one related to asylum and refugee law, and the other pathway relates to work permit status or perhaps entrepreneur types of applications based on the business that is being operated by the candidate. So this individual, there's kind of a structural concern here, because when you apply for asylum in the United States, that is a strong indicator that you fear returning to your home country. So when you think about that, then an officer says, well, this person fears for their life, that if they return to their country, they could be assaulted, or they cannot practice their faith or something along those lines. So in other words, that means there's an indication that you never intend to leave the United States. Well, let's talk about this, let's say pre-Trump, where the presumption was you would get a set of due process in the asylum process in the United States, although now I think that's in question. So if we look at what a Canadian officer would think about that in relation to, let's talk about a work permit in Canada. Let's say you have some very specific skills related to medical billing, which are directly transferable to one or two employers in Canada so well that they want to issue you a job offer. And let's say they did do the labor certification process, the LMIA, and let's say it was a positive one, which means they're not displacing Canadians in the labor market. Then what would happen is the positive LMIA would be submitted to a Canadian visa office in the United States, and the officer would be tasked to determine whether you can do the job that is being offered, which probably sounds like they would be satisfied about that, but also that if your temporary status in Canada ceased, like your work permit was no longer valid because of the passage of time, that you would leave in the event that you cannot change your status to permanent residency. So there'd be a lot of explaining you'd have to do to say that I will leave, despite the fact that I made a refugee claim in the United States. And this is key because, as you may know, or as you should know, all of the English-speaking countries do share criminal and now immigration information. So Australians know if you had a visitor visa rejection to Canada, and Canadian authorities know if you applied to Australia and had a work permit rejection. They would know that. So I know anecdotally, during the first Trump administration, it's weird calling it administration, given what it's turning into, but during the first Trump government, there's an anecdote on our lawyer discussion saying somebody did apply for a study permit to Canada between 2017 and 2020, despite the fact that they were an asylum seeker in the United States, and it was apparently successful. So it could be maybe the environment was different back then, but there's a lot of uphill presumptions in relation to this set of circumstances. And it's a bit of a dense question because the person also indicated, I talked about arguably entrepreneur categories, given the fact that there is, I'll presume, a successful business being run in the United States. So the idea for that is when we think of entrepreneurs and we're thinking of provincial nominee programs, most provinces have an entrepreneur stream for this. And if I just look up some basic criteria here. So entrepreneurs, in terms of the very, very essential components, you have to invest between 250,000 to 350,000 Canadian to establish or purchase a business in Canada. There's also the startup visa program where you could get 75,000 from a designated angel investor group, and they're distributed through business incubators in Canada. And then the way most of the provinces work is that it's conditional PR. So they like your business plan. They like the amount of money you're going to be putting in. They like the fact that you're going to hire 2 employees for this business. Or similarly, you're buying a business and you're going to maintain the 2 employees in this business, and it's in a smaller city, and it's a business that is beneficial to the community. In either situation, though, they say, okay, we like this plan, and they effectively adopt that business plan as a set of terms and conditions that are imposed as a precondition for permanent residency. So what that means is they will give you a letter saying, thank you for the business plan. We're going to stow this away and review this business plan. And they'll give you a letter to apply for a work permit. And then that letter would go to the federal immigration authorities, and presumably you would be issued the work permit. And then over the course of perhaps 20 months, depending on the province, you check in with the province based on the progress of your business, looking at the gross turnover, looking at the amount of employees. And after a 20-month period, if the provincial authorities are satisfied that your business plan was borne out in reality, they would give you another certificate, a certificate of nomination for permanent residency. These are kind of rare. I mean, I advise about these, but I have not done these since pre-COVID because, I don't know, the business environment is kind of difficult. But if I apply this sort of general set of criteria to this individual, who, again, is an asylum claimant in the United States, one thing that stands out is that for these provincial nominee entrepreneur programs, they oftentimes have their own point system, and that point system allocates points for visiting Canada, making an exploratory visit. Because if you're going to spend $250,000 to $600,000, it's reasonable to look at the business environment personally, not just through the lens of a business broker, for example. So asylum seekers, structurally speaking, they may not be able to re-enter the United States, and that could be an issue if you have family, if you're not single. And then you may be stuck. Either you may not be able to even enter Canada, or if you do enter Canada, then you may not be able to return to the United States. And then you may be facing persecution if you are an asylum seeker, as was indicated here. So I hope I addressed most of the general issues there. If not, maybe repose it. And we still have time for an additional question here. So it mentions my IELTS test, IELTS, will be expiring 15 December 2025, so about a couple of months from now. I hope I can launch an express entry application based on the scores. Am I supposed to repeat the test? So this relates to the requirement that the express entry requires English or French language test of, I believe, less than 2 years duration. So I would opine that the sort of lock-in date to have the validity of that IELTS test should be, let's say, December 10th or something. So your profile should be deemed complete namely with the third-party documentation, such as passport scan and IELTS test scan. And that should be allowing you to use that IELTS test as credible within the 2-year window. And the PTE, I think that's an alternative one. I haven't looked it up, but the IRCC website will confirm the additional tests besides the IELTS test. I know by memory there's also the CELPIP test, which I think is available in North America. PTE, if assuming it has a listening component, then it's probably approved as well. Other tests like TOEFL, they don't have a listening component, so they're not approved for the purpose of express entry. But the best authority would be the immigration website of the Canadian government as of now, because these things change from time to time. So with that, we still have some time. There were some questions somebody asked me to answer. They said they would look this up, and I promised to answer that question if I can look it up here. Let me see. So the oh yeah, some person indicated I have a CRS score of 375 according to their own assessment, and they want to apply for a PNP program and need guidance. So a lot of that is sort of overlapping what I said before, except to be a bit more specific. Each province and territory has their own distinct immigration stream based on labor market needs, including skilled workers and, like I've discussed, business people or entrepreneurs. So assuming that you have the appropriate profile and credentials registered with the province, then you would get an additional 600 points on the federal express entry score system, which guarantees that you get selected for the invitation to apply. Now, as I indicated earlier, there's a separate point system for Manitoba, which does not use the federal express entry system. So you'd have to pursue that separately for this. And I think another question related to I have, these are all point questions. Is it better to have a job first and then do express entry or PNP separately if my points are around 429, namely single applicant with MBA? So what is the fastest PR options? So when you're at 429, I mean, again, in this environment where the point draws are normally 525, 535, you have to think strategically. So that would have been a good score. But now you're going back to provincial nominee. If there's anything that you can get the 600 points through, then you don't need to sort of try to eke out all the other points through the traditional methods, such as improving English or getting French. Again, if you're 429, sounds like you're not over 35, or maybe you're just around that age, right? But keep in mind that express entry, the system ranks candidates about every 2 weeks through the rounds of invitations. So the bottom line is that the targeted draws are the ones with the lower points, namely, and they're targeted based on occupation. So you'd have to definitely look at the history of the targeted draws and compare it to your work experience to see if there is any hope that way. If not, then you're looking for PNP, but the short form for PNP is often like certified job offer, which is getting more and more difficult to obtain these days. So the other questions people have posed before which I just want to get to because I know they will ask me by email if I did answer this. So there was a similar question to PFL. I think I've answered that one. So then, when we look at the other question specifically here. Okay, so this one is, okay, I'm an RN in Kenya with over 12 years of experience and hold a BSc in nursing. So how can I relocate and practice in Canada? So this is a really good question because there is an ongoing shortage of allied health professionals and doctors and nurses. So generally speaking, internationally trained nurses must complete credential recognition processes before practicing in Canada. I believe it's the National Nursing Assessment Service. They evaluate nursing credentials against Canadian standards, and nurses choose a destination province and apply to that province's regulatory body. And the requirements are generally passing, I forget the acronym, NCLEX, RN exam. I think that's a standard exam, and the IELTS test as well. And in some cases, the provincial regulators for nurses of that province, their examinations. And then after that, again, this would probably be a case which is subject to the benefit of the lower, i.e. targeted draws. And so having that licensure makes you a viable candidate for permanent residency, assuming your age isn't too far off above making a deleterious effect on the points for that. And again, I mentioned Nova Scotia, which again has its own pathway for nurses. This person's from Kenya, so in the United States, if you have U.S. Licensure, then it's a lot faster because they just assume the credentials don't have to be scrutinized quite as much. So, in other words, it's foreign credential evaluation, then go to express entry. And if your age is not too high, then you might simply get selected under the auspices of a targeted draw. So with that, I think there's a couple more questions, and I still have time here. I want to get to these in case these people email me again. So this one I think is sort of straightforward, which is family sponsorship and relationship-based applications. The sub-question is here. I'm a Canadian citizen and would like to sponsor my girlfriend as common law. We don't have a joint account or shared lease, but she files taxes. And at the same address, she's added her to my phone line and my bank account. Is that enough proof? Okay, so in terms of the basics, common law partners must demonstrate 12 consecutive months of cohabitation in a marriage-like relationship, and our immigration department accepts various forms of evidence, including joint leases or rental agreements. There's shared ownership of residential property, joint utility accounts such as gas, electricity, telephone, so shared banking or credit accounts. Maybe if you have a car, then if you both drive, you're listed as insurance beneficiaries. Insurance policy beneficiary in general is a strong sign. Photos, I would say, with key people in your life, like close family and friends, is useful. Travel records, there should be communication logs depending on how distant you are from each other. What else? A key thing is the formative aspect of this, leading to the initial 12 months. When did that start? There has to be a significant cogent set of evidence at that 12-month demarcation point. The common sense one is lease, but if you don't have a lease, maybe you lived with your parents. Your parents could write a letter saying, well, yeah, they lived here in the basement or something. That would be like a foundation for this. This person is adding a partner's phone line to the account and filing taxes at the address. It's in and of itself, that's insufficient. We need more than that. You need some of the information that I've given as examples for this. So we still have some time. I just want to get to any other questions that were sent ahead of time here, which is related to, I think, the intersection between refugee and humanitarian and compassionate. So one is, as a refugee protection claimant, my work permit will be expiring in 7 months. Is it permissible to apply for an extension now? So in this instance, the person is a claimant for refugee status, which means their refugee claim has not been disposed of. So they are able to apply for a work permit pending the outcome of their refugee claim, which is not disposed of yet. So you can apply for a work permit extension before the current one expires. The department advises applying at least 30 days before. We don't always do that, but that's sort of what they like to see. And the obvious benefit is simply applying before gives you maintained status. So even though you do not have the subsequent work permit in hand, you can tell your employer that you have maintained status. We've given these letters to clients outlining the law, stating that if you did file for your work permit extension before it expired and you're under the same terms and conditions after the expiration, then you should be allowed to work in Canada without the issuance of the brand new work permit. So with refugee claimants, they're awaiting the final decision. In those situations, I don't even think they pay the processing fee because they're already in a presumed amount of hardship already. And down the road, if the final decision leads to the refugee claimant being a convention refugee or protected person, then while you're waiting for the permanent residency, the fees, I think, are still exempt. On the other hand, if the refugee claim is refused, and if you're going to federal court to challenge the negative refugee claim, then you should have to pay the processing fees for that work permit. I think we still have some time. I want to just answer these questions, as many as I can. So I guess this relates as well to refugee, where it says, I filed asylum and withdrew my claim while on a visitor visa, and then left 6 months ago under removal. Okay. Am I banned, or can I start an immigration process again? So this is an extremely important question, because when you withdraw an asylum claim while you're in Canada, then the question is, did you register your departure with the Canada Border Service Agency within 30 days of withdrawing the refugee claim? If you did, then you would get a certificate of departure. And then in that instance where you've left less than 30 days from the withdrawal of your refugee claim, then you would not get the deportation order. And then you would be free to apply for a new type of permit to Canada. It's not as straightforward, but at least you would have to explain that, no, you no longer have a fear that touches upon the asylum criteria. That's why you withdrew the claim. And that way, in that, by not leaving past 30 days from the date of your refugee withdrawal, then you don't need an authorization to return to Canada because you weren't deported. You were leaving of your own accord. So you have to make sure that's the case. I hope that is the situation for this person who's considering stopping the refugee process and coming through a less discretionary pathway, hopefully with some more specificity. We'd know that. So I think I just have a couple more questions here, which is, Okay, can I apply for a spousal open work permit while waiting for permanent residency after a refugee claim was refused? Okay, so this is a common phenomenon for people who are inside of Canada, where, well, let me go to the basics. So a spousal open work permit, the eligibility for that depends on the sponsor's status and the applicant's circumstances. So if the spousal open work permit, it's a little bit technical, but if one of the people holds a valid study permit or work permit, generally speaking, their spouse or common law partner can qualify for an open work permit. That's been modified more recently based on the fact that the work permit holder, the initial one, has to be working at a certain skill level. And similarly, if the main person is on a study permit, be studying at the master's level typically, or bachelor's, or have be in a professional program, then you could apply for a spousal open work permit. But in this case, it's more complicated because the individual was refused. Some people might have joined. They can pose a question in the chat because I'm still here for a few minutes. So in a situation where there's a refused refugee claimant, they would have to address their immigration status before applying for a new permit under one of these auspices, namely the spouse's status. So, for example, pending permanent resident applications under certain streams may enable a work permit application to be filed. This issue of restoration doesn't really work here because a refugee claimant is already from the beginning, the outset, they're under a conditional removal order. So it really just has a very deleterious consequence when you're a refused refugee claimant. If you want to work, you can, and you don't have these kinds of things, you can still file for a work permit if you don't have a spouse on an open work permit. But as I've indicated, you have to file with the government fee, and you have to demonstrate that you're under an unenforceable removal order, which means you're in Canada because you have a pending appeal. And that appeal is such that the Canada Border Service Agency is not permitted to deport you. So a couple of other questions I just want to get to here, which is that relates to post-graduation work permits. So if we see here, let me see. Is it better to withdraw and reapply for a PGWP once a study permit extension is approved, even if the 90-day period has passed, but still within the 180-day window? So these dates are quite critical for a PGWP because the foundation for PGWP is that you've been a genuine student, and you have to have that status when you're filing for the PGWP. And the person did reference the fact that they can apply for a PGWP. It has to be done within 180 days of meeting the requirements for graduation. So in a case like this, where the person has to keep these touchstone dates in mind, you want to have maintained status. If you withdraw an application, you must make sure that there is still some subsisting application, so you do have maintained status. And with that, it might be strategic to apply again. So if the study permit expires before applying, applicants have 90 days to apply for a PGWP combined with the restoration of status as a student, because you need that study permit status to get the post-graduation work permit. But because it sounds like there would be a broken chain of status, then during the restoration period, the person can't work in Canada until the PGWP is approved. This is in contrast to people who file for the post-graduation work permit in a timely way while they still have the initial study permit status. And then usually for their last semester, they can start working because the presumption is sometimes they're not subject to a full course load. So that's a very technical question. You want to get more specific legal advice, because if you've misinterpreted the facts, or if I miss something, then I don't want to be in a position where I'm advising you to work when you're not allowed to work. So I see some questions in the chat I can try to get to here. It says, I have a pending asylum case here in the United States. I'm planning to move to Canada. I have a visitor visa. Will I be eligible to file for an asylum there, as the wait times are very long? I guess the wait times are long in the States. Well, they're getting long in Canada too. So this issue about the ability to make a refugee claim in Canada while there's already a pending claim in the States, it's really in flux, because we have pending laws that are being debated, Bill C-2, and now it's amended as Bill C-12, where they might cut off the ability for anybody to make a refugee claim in many circumstances. For example, if they've been in Canada already for more than a year as of June 2025. Your particular circumstance, what's relevant is the Safe Third Country Agreement, which says that generally speaking, you cannot make a refugee claim in Canada if you've landed in the United States first. There's some exceptions to that, like if you have a close relative, then you don't have to pursue the refugee claim in the United States. You could say, I've got like a brother or sister or parent, maybe uncle and aunt too. I'd have to double check that. Then in theory, you could apply for asylum in the United States. I've come across this pre-2020, and some laws might have changed then. But before 2020, when a person made a refugee claim in the United States that was not disposed of, and they managed to make a claim in Canada, it simply became another issue for the refugee judge here to pursue, namely, why did you make the claim in Canada? I mean, I could sort of see now in this post or current Trump situation that you may not feel you'd get a fair shake in the asylum process, since there's a politicization of judicial decision-making, which is the opposite of what you'd expect in a democratic country. So in the worst case, if the pending bills in Canada are going into effect, in their worst interpretation, you would not be able to make a formal refugee claim, but you'd be able to approach the border and make an application for a PRA, which is a pre-removal risk assessment. A PRA is like a sort of, it touches upon the same subject matter of a refugee claim. It's just that there's no right to an interview. And more importantly, it's not made by an arm's length court. It's not made by the court known as the Immigration Refugee Board. It's made by a bureaucratic officer, and they have their agenda of maybe enforcement might interfere with their objective ability to assess this type of refugee subject matter if it's done in the PRA fashion. So a lot is in flux there. You might want to ask that question again, depending on if the proposed laws here pass, Bill C-2, or as modified as Bill C-12. Another question is, does Canada have physical interviews for study permit holders? And they don't really, as far as I know. I have not seen one in many, many years, just because of the volume of candidates. Although that, I suppose the volume is going down now, but still, they just fired 3,000 immigration officers, I think, in the past 6 months. And because of that, an officer told me that she's doing the work of 4 officers. So I don't think they have the ability to interview study permit candidates. Another one is, I think there was a question related to the refugee in the United States thinking about Canada. They said they've got a cousin with a pending refugee case in Canada. So for that, I don't think cousin's on the list. So, I mean, I can maybe double check down the road, but even if cousin is on the list, there, like I said, there's been some modifications to this such that if you, in some instances, if you've merely filed the asylum claim in the United States, then you may not be able to commence the formal refugee process, but only get the risk assessment even now. It's something I'd have to double check because as we get to the presumed conclusion that refugee claimants in the United States may not get a fair chance, then the Canadian government might overreact just for fear of having too many U.S. asylum claimants trying to cross the border. They might restrict it even more, hence these bills I've been talking about. The question here is, can I convert my Canadian visit visa to another category? I've got a master's and 4 years professional experience. This kind of touches upon what I mentioned earlier in the webinar, which is if you have a Canadian visit visa, it's sort of a good sign because that's an indicator that you have some ties to your home country and you've satisfied the officer that you will probably return as a visitor after visiting Canada. But any other category, visit visa to student or visit visa to worker with the study permit pathway, you need a genuine study plan. And I hate to just use genuine arbitrarily, but what that means is that it has to show that the purpose of studying is not to be in Canada to get a job, but to enhance your labor prospects in your home country. That's what the study plan would have to be after getting a visit visa and switching that to study permit. In terms of work, it's really get a job offer that's certified, unless you come from a Western European country or Australia, where there's, depending on your age, you can work under the international experience class without too much difficulty for 1 year or so, or 2 years, depending on which country you're from. UK, I think it's 2 years or something. So let's see if I want to see if there's any other questions. Let me see here. So I think there was a follow-up question to somebody who wanted to apply for asylum at the airport. I think the concern there is you'd want to double check if what the laws are going to be soon in Canada. They're in the midst of modifying these, but in the worst case, if you're lucky enough to come to the airport, then this is anecdotal, but I've seen that they oftentimes don't necessarily take a negative inference from the fact that you filed a refugee claim in the United States, and they might, for whatever reason, they might possibly process the refugee claim and not turn it into a pre-removal risk assessment for this. That's not legal advice because you'd have to consult with us, and that's like a life-changing thing you're considering, just flying to the port of entry. So we'd want to look at your circumstances in some detail to see what option for entry to Canada there would be in your particular circumstance. So I just want to see if there was one more question on the previous chat. I think related to that is, yeah, it is better to get a PhD in Canada because there is a pathway for that. And I just want to see if there's one or two more questions here. related to this. So there's one very narrow question, which is an investor or entrepreneur candidate establishing an agri-food business in Newfoundland and Labrador. Okay. So what are the conditions? Okay, that's really broad. So agri-food businesses in Newfoundland and Labrador might qualify for their own provincial nominee programs targeting specific industries. I think sometime in the recent past, I think they have a factory that processes fish oil into omega-3 oil. I think they have endeavors like that already in some of those maritime provinces. And but it goes back to what I mentioned earlier. So in this agri-food endeavor, you need that comprehensive business plan to develop and demonstrate the viability, competitive advantage, and job creation potential. That's really the biggest thing, is job creation potential, like real viable jobs that are not short-term jobs. And that comprehensive business plan is pitched to the provincial immigration authorities, and then they give it a rubber stamp of approval, but they scrutinize the progress of that business. And then you could maybe get a provincial nomination certificate on the strength of that business, which leads to the ability to apply for permanent residency. As I mentioned earlier, it's like a 20-month, depending on the province, they're monitoring your business for 20 months for this. And then after that, they would issue that certificate and you would be on your way for permanent residency for this. And I think there's a question related to, I think, that asylum and entering Canada. So if I go to my home country after withdrawal in the United States, then spend some time in the home country or any other country, and then go to Canada from my home country and do asylum, will they have a record of my U.S.A.'s case? Yeah, definitely. If you've entered late, then you missed what I said earlier, which is that there was this concept of the 5 I's. So if I remember the I's correctly, UK is one, United States, Canada, Australia, New Zealand. Those are the 5 I's, the English-speaking countries. So they share not just criminal activity information like charges or convictions, but also immigration history. So if you've been refused a visa to any of these countries, the other countries will know about it. Sort of as an aside, if you're asked on any immigration form, if you've ever been charged or detained, even if you were not convicted, you have to mention yes, because they're explicitly asking you. We just come across this from time to time. So that means just something I always just throw out there if people are doing something on their own. I think a related question to what I just said is the Schengen region of the EU. Is that included? It's not included as far as we know. Now, there are spooks in every country. And like Canada, we have CSIS. America has the CIA. So if you're a person of interest, then they do have means, but they expend those resources carefully over and above the 5 Eyes network. So I don't want to say you're completely safe, because there's these sort of semi-secret spy agencies that every country has that put their resources to bear on certain individuals who fit a certain profile. I'll just assume you're one of those people, because I want to err on the side of caution. And then there's a question related to, I've been refused a U.S. study visa before. Will this have an impact on applying for a Canadian study visa? So for this, the short answer is yes, but I don't want to just leave it at that. I want to give some context. So lawyers are really big on context, because it could be our sword or shield, depending on how good our client's case is. So in the best case scenario, if the the fact circumstances are analogous to like a sword. You can wield it and say, um, I was filing the study permit and the environment, the climate was negative for that. And the officer did not exercise due process or due diligence when wrongfully refusing my study visa to the United States. And then you could try to contextualize it that way. On the other hand, if the study permit application to the United States was done simply with inadequate documentation, there's still a defense there, but then you'd have to explain why was the documentation inadequate? Did you hire a lawyer that wasn't communicating properly with you, or some other kind of reason? So it's not fatal, but when resubmitting a study permit application to Canada in the face of a previous refusal, you really want to set aside any doubt the Canadian officer might have by showing that your intention to be a temporary resident in Canada should not be doubted just because U.S. authorities refused your study visa, perhaps because of some arbitrary reason, or perhaps because they did not have regard to the material that indicated a strong U.S. study visa application. So I want to see if there's any more questions here. There's one here. It says, can I maintain my legal status in Spain after withdrawing my asylum in the United States if I don't have asylum in, I suppose, that other country? So that question, that touches upon the visa laws of another country. So I can't opine on that because I just know Canadian immigration law. It sounds like, if I'm speculating, but it sounds like you have the ability to return to the EU. So you have some kind of status or a passport for that purpose. I think that's all I can really say about that question. So I think I just want to make sure I answered any other questions that were pre-submitted here, right? Oh, this seems a bit case specific. Let me see here. My parents' super visa application was submitted at the end of May, but no medical exam request was issued yet. I guess now it is quite a few months later. It's October. Should I submit an upfront medical via the web form or wait for IRCC's request? So since super visa applications typically include medical requests during the processing, so a submitted super visa application at the end of May, and now we're in October, without a medical request, I think it just simply suggests slower processing or some administrative backlog. You should have regard to the published processing times. They're not necessarily accurate, but they give you a sort of relative stance of where you sit in relation to other candidates. In theory, the solution you're proposing, which is an upfront medical submission via the web form, that could expedite the processing, but it might not be necessary if the immigration department has not specifically requested the examination. Keep in mind as well that medical examinations are valid for 12 months from the examination date, and submitting an unsolicited upfront medical might cause administrative confusion if the Canadian Immigration Department systems have not yet triggered the requirement. So I think you should monitor the application status through the online portal, which I presume you have, and respond when they ask for that medical. So then I think there may be one more question, a previous submitted question, which is, it says, I intend to relocate to Canada. What is the best route that avoids a language proficiency test? Okay. All I can think of off the top of my head is get married to a Canadian in a genuine marriage. Then they don't care if you don't speak English or French. But As far as other categories, I mean, if I think of a niche one, like maybe a humanitarian case where all of your children are in Canada and you have no status in Canada and you have no relatives in your home country and you're not good at English, and maybe you've got a deleterious health condition that can't be treated there, or you're part of a minority that is severely discriminated against. That could be a situation where you don't necessarily need English language, but you're showing that you have a support network in Canada that can support you despite your lack of English or French language ability. So that'd be the only way I can think of for this. So let's see. I think there's a follow-up question here. I hope I can match this to the previous poser of the question where it says, the only concern I have is I can't go back to my country, and the current administration is deporting without trial. One of my friends is in detention, I guess in the States, they're speaking about, for 2 months. And I have to save myself and my family. If I have to come to Canada by air, would I be eligible to apply for asylum in Canada? Yes or no? So they want a categorical answer, keeping in mind I have a pending claim in the United States. I'm going by memory, but there was a change in 2022, which might have made it impossible, depending on the stage of your refugee claim. So I don't want to say yes or no. If you come by plane, definitely yes or definitely no. The thing I can say most safest, which is not the best, is that you would get at least a pre-removal risk assessment. If I can recall the changes in policy, because these changes for the Safe Third Country Agreement have been affected by litigation in Trump 1, where the federal court for a while, during, I believe, 2018, did say that the United States was not safe for refugees. But then I think in 2020, it went to the Federal Court of Appeal of Canada, and they said, no, the US is still safe. But then that was when the Biden presidency was going on. So that issue is so in flux. And then because of the sort of backlash against immigration in the past 2 years in Canada, they've made the land crossings much more difficult. So for that, because the stakes are so high, you have to consult with us. I mean, we do refugee cases. It's better if you consult maybe through a friend, because we don't like to consult people who are outside of Canada talking about a refugee claim unless they're immediately at the border or at the airport. Just the way the laws are structured, that ethically speaking, it's preferred that we consult with somebody about asylum cases if they're already here, or if they're needing advice because they're interacting with a Canadian border officer in the next hour. That's when we give specific advice. If you have a friend in Canada, we can have a private consultation and deal with it that way. But that's sort of the pretty well most of the questions I have. So I hope for people who are tuning in and people who may come across this on the social media, I hope this is useful. So if you do have a substantive question and want customized legal advice related to your individual circumstances, then you could reach out to us at www.chaudharylaw.com, and the intake email is clerk@chaudharylaw.com. So that's Chaudhary Law, CHAUDHARY, law.com. So with that, I hope you enjoy the rest of your day. Thank you. Bye.